All right, welcome to the 294th District Court. My name is Judge Chris Martin. I'm going to call this morning's criminal docket. When you hear your name, please say present or here. James Brown.
James Brown.
0 for 1. Kenneth Taylor has been verified in Russ County, CR 22195. We will recall that case. Kenneth Warrington. Jesse Epperson.
Here.
Monica Roberts. Mr. Lee.
Judge, she's here, she's out in the hall.
Thanks, sir. William Gouldner. And I show that Mr. Gouldner will be appearing via Zoom along with Mr. Head or Mr. Weiner. And both of them are present in the Zoom room, so we will call them back up shortly. Johnny Cooper.
Yes.
Ronnie Cotton.
Present.
CR 2310, James Dwayne Dennis, waiver of arraignment filed, approved, pretrial set May 11th. Mark Allen Harrison.
Mark Harrison. There you are.
All right, I believe that there's a 1719 for Mr. Harrison on this case. Treasurer Hollick. Thank you, Mr. Waddell. Jonathan King. Jonathan Kentrell King.
Jonathan. There you are.
All right, and I believe there's also 1719 warrants in each one of these cases. Benny McFarland. Miranda Opry. Miranda Jill Opry.
Miranda Opry. No, Your Honor.
Kristen Sipes.
Kristen Sipes. No, Your Honor.
Does Mr. Manning have any of his clients anywhere? They talking to him? Hey, Mr. Manning, I didn't see you. Good morning, sir. You're not hiding with your clients anywhere, are you? Okay, good. Michael Sprouse.
Michael Sprouse. No, Your Honor.
Let's go back. What are you batting on?
Next.
You're still doing okay.
Better than the
But
rest.
then he says call the next one quickly. Dennis Stanley. There we go. Avery Tienda.
Avery. No, Your Honor.
Marcus Turner, CR 21343. Court shows that he's been verified in Dallas County, so we will recall that case. Caleb Waller.
Judge, he's present.
Thank you, Mr. Manning. Charles Young.
Judge, he's present.
Thanks. Lindy Delaney.
Mr. Merlater is going over plea papers with her.
All right, thank you. Naomi Escovel.
Here.
Andrea Young. Mr.
Andrea Young. Here, Your Honor.
She's here. All right. And Mr. Thorson is appearing via Zoom and he is present. Oscar Duran. Jodine Lewis.
Mr. White is going over the paperwork with her and Mr. Riggs today.
Okay. So Kenneth Allen Riggs is present as well. Okay. All right. Do we have anyone whose name has not been called? You check the hallway.
No, Your Honor.
Okay, do you have any attorneys that are ready? Mr. Manning, you ready?
Yes, Judge, I was just recently appointed on Mr. Warrington.
Kenneth Franklin Warrington, CR 22257. All right, Mr. Warrington has found to be indigent for purposes of the Sixth Amendment. Mr. Jonathan Manning has been appointed to represent Mr. Warrington. Have you had an opportunity to be presented with the indictment?
Yes, Judge, we've gone over the indictment, his name is spelled correctly. We understand the charge remains punishment against him. This time he pleads not guilty of the request to be set for pre-trial.
All right, court will enter Mr. Warrington's plea of not guilty into the record. We'll set this matter for pretrial. Mr. Manning, are you available on May 11th?
Yes, Judge.
All right, let's set Mr. Warrington for pretrial on May 11th. Who you ready on next?
Judge, ready on Mr. Johnny Cooper.
Mr. Cooper, if you'll come forward, CR 2326, CR 2239. Mr. Cooper set for pretrial.
Yes, Judge, I believe we're set for pre-trial. Last time I spoke to Mr. Cooper, he was in custody. He has some documentation he'd like to provide that may provide an affirmative defense for CR 2326. I request that we reset the pre-trial so I can gather the information from him.
All right, court will set Mr. Cooper for pretrial on May 11th. That'll be at 9 a.m. Probably in this courtroom. All right, you're free to go.
Thank you. Yeah, shoot that down. Judge, also ready on Mr. Cooper.
Ronnie Dwayne Cotton, CR 22240. Mr. Cotton set for pretrial.
Yes, Judge, I recently received a offer from the state as well as some other information I need to go over with my clients who request a additional pre-trial on this case.
Any objection from the state? All right, court will set Mr. Cotton for pretrial on May 11th. And Mr. Cotton, the pretrial release department is requesting a urinalysis today. So I want you to meet with them outside and you're not free to leave until I tell you you're free to leave, okay?
Sure.
All right. Go see Mr. Waddell.
Judge, I think that's all I have ready right now. I'm going to go ahead and get some please done.
Okay, we have anyone else that's ready?
Yes, Judge. Morning, I'm ready on this SQL.
Good morning. Ms. Escobar, if you'll come up, please. All right, this is CR 21286. State versus Noemi Escobar, and I show that this is motion to revoke.
Yes, Your Honor.
Any announcements?
At this time we are requesting an extra setting judge. We just got retained. We requested a copy of the motion to adjudicate. State has provided that today, sent us an email with that discovery, so that we can review it.
Okay. All right, court will set Ms. Escobar for the contested docket on March 30th. y'all reach an agreement that day, we can take it up that day. If not, then we'll go forward with the testing for the next 3 weeks.
I'm gonna be out of town, is there sooner is fine or later, whichever you want, but that particular day I'm out of town.
What about March 28th?
That's fine, Judge.
All right.
What time, Judge?
It'll be at 9 a.m.
Thank you.
You're free to go.
Thank you, Judge.
You are. Joe, are you ready?
Yes, Your Honor.
Jesse Epperson. CR 2296, CR 2297.
Yes, Your Honor, we're here on the docket call and I believe it's there's an agreement to reset the docket call. We're trying to work on getting an agreement done in this case. I think we're very close to removing additional time.
Any objection from staff? 30 days sufficient? Or a little more. How about March, not March, how about April 25th? April 4th or 25th, whichever one.
25th would be great.
All right, court will set Mr. Epperson for docket call on April 25th at 9 a.m.
Your Honor, that concludes my business. May I be excused?
Yes,
Thank you.
there you go.
Thank you.
All right, I'm gonna bring in Mr. Goldner and Mr. Weiner. Yes,
I
ma'am.
was gonna say, Avery, Tianda, Avery, and Miranda O'Cry. Here.
Did y'all hear that, Miss Albright and Albright? I'm gonna bring in Mr. Weiner and Mr. Goldner. Says Mr. Goldner is still connecting audio. We'll give him just a moment.
Thank you, Judge. And I appreciate you letting me appear by Zoom. I've got a bunch of places to be this morning. I appreciate being accommodating.
You're welcome. All right, Mr. Goldner, I'm gonna ask you to unmute right there. If you'll just click that button. There you go. Mr. Goldner, can you see and hear me okay?
Yes, sir, I can.
All right, can you see your attorney, Mr. Weiner, on your screen as well?
I can see you and I can see me. That's it.
All right, so what you may have to do is swipe left or right on your phone, and you'll see the other people in your hearing. So if you just
Okay.
put your hand and move it, Mr. Weiner is present, as are the attorneys for the state in the courtroom. So if you want to see Mr. Weiner, just kind of swipe left or right on your screen, and you'll see them. Okay.
Yes,
All
sir.
right. This is cause number CR 22-376, State versus William Corey Goldner for pretrial. Go ahead, Mr. Weiner.
Yes, Your Honor. We have no pretrial at this time. However, I spoke with Mr. Head. This case revolves around, I guess, at least in our eyes, a notary. We are still looking to gather some information about that person's notary license and kind of the history of it. And so I don't anticipate there will be pretrial in the future, but I at least wanted to make a brief record that if we do discover something, we may ask for leave to file a late pretrial motion. But at this time, we have no pretrial for the court.
Okay, court would grant the defendant leave to file late motions on pretrial issues should it be needed. Court
Thank you,
will-
Judge.
You're welcome. Court will set Mr. Goldner for docket call. Are you available on April 4th or April 25th?
Take a look, Judge. Let's do the 25th because I don't have anything on my calendar so far.
Okay. All right. Court sets Mr. Goldner for a pretrial hearing on April 25th, and that will be at 9 a.m. And that'll be an in-person hearing.
At 9 a.m. Okay. Thank you so much, Judge. May we be excused?
You are excused.
Thank you. Have a good day.
You're welcome. Thank you, Mr. Goldner.
Thank you.
Yes, yes. Andrea Young. Just wait for Mr. Thorson to join online. Hey, Brian, do me a favor. Yeah. You give this to Steve.
Sorry, copy here.
It is. All right, good morning, Mr. Thorson. Can you see and hear me okay?
Good morning. I'm sorry.
Yeah, no problem. All right, this is cause number CR 22-121. This is set for status today on the court's ruling on the defendant's motion to suppress. The court, having considered the motion, the evidence presented in support and the arguments of counsel, the court has denied the motion to suppress, and the court has issued its findings of fact and conclusions of law. I filed those of record today, Mr. Thorson. I'll have my coordinator email you a copy.
Thank you, Your Honor.
So that you'll have those. So we'll set Ms. Young then for docket call. You have your calendar available, Mr. Thorson?
I do, Your Honor.
All right, are you available on April 4th or April 25th?
Is that a morning docket, Your Honor?
Yes, sir. Yeah, I do all my bail defendants in the morning. I do all my jail defendants in the afternoon.
Let's go ahead and the 4th will be fine. So the morning of Tuesday, the 4th.
Yes, sir.
Okay.
All right, court sets Ms. Young for docket call April 4th at 9 a.m. in this court.
Thank you. And Ms. Young, if you're present, we'll talk later. So, all right. Thank you, Your Honor.
I don't know if you heard her. She acknowledged you.
Yes, sir.
All right. Thank you, Mr. Thorson.
Thank you, Your Honor. Appreciate it.
You're welcome. All right, we'll go ahead and call CR 22-195 State versus Kenneth Lee Taylor, verified in Russ County Jail. I had him set to status on hiring an attorney. So we'll reset that to April 4th. I'll tell you what, let's set that April 25th for arraignment and status to hire attorney. You don't have any additional information on what he's in custody for at all?
Traditional call market health.
Yeah, I think we're just in a holding pattern now.
Say just as Mr. Turner's in Dallas County, just called and said that. It wouldn't have been great.
For the record, this is cause number CR 22-224 and CR 22-225, State versus Monica Rochelle Roberts. Ms. Roberts, you'll raise your right hand. I'm going to place you under oath. Ma'am, you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God. All right, you can lower your hand. Just speak up loudly and clearly for me. Ms. Roberts, are you a United States citizen who reads, writes, and speaks English?
Yes,
Have you ever been diagnosed with a mental condition?
yes.
Can you tell me about that?
It's just been, they said I had bipolar one.
Okay. Are you currently on medication or under treatment for that? Okay. Do you feel like you have a rational understanding of this case and what's going on here today?
Yes,
Okay. And in this case, you're represented by your attorney, Mr. Steve Green. Are you pleased with his representation of you? You feel like you've had enough time to talk with him about your case and have all of your legal questions answered?
yes.
You've signed some paperwork here today. Is there anything about this paperwork that you've read over and signed with Mr. Green that you do not understand?
Also,
Mr. Green, do you believe Ms. Roberts to be competent today?
I do,
And have you seen any evidence of anything that would give you concern as to her competency?
no, Judge, we have talked on several occasions about, mental health condition, the fact that she is, participating in treatment and on medication for that, and it's, that leads me to believe that she is competent.
And you've explained to your client her rights with regards to this plea and any of the consequences of a felony conviction.
I have,
You believe that she understands those and that she's entering into this plea intentionally, knowingly, and voluntarily.
I do.
All right, Mr. Roberts, in cause number CR 22-224, you are charged with the third-degree felony offense of evading arrest or detention with a vehicle. If convicted and sentenced, that carries a range of punishment of not less than 2 years in prison or more than 10 years in prison, and carries a range of, carries a fine of not more than $10,000 if imposed. I see that the plea agreement in this case is that you would plead guilty to evading arrest or detention with a vehicle. The state would be recommending that your sentence be assessed today by the court at 10 years in prison, but they're recommending that that sentence be suspended and you be placed on probation or community supervision for 7 years. You would pay a $2,500 fine, $290 in court costs, $180 in restitution, $35 in reimbursement fees. And the state, as part of this plea agreement, would dismiss the indicted cause CR 22-225, which is possession of controlled substance. And they would also dismiss their unfiled DA 2021-1452, which is a tampering or fabricating with physical evidence. Is that your understanding of the plea agreement today?
yes, sir.
And that's what you're asking the court to approve? All right, Ms. Robertson, how do you plead to evading arrest or detention with a vehicle?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty today?
No, sir.
All right, the court will accept the defendant's plea of guilt. Mr. Green, any objection to the state's evidence?
No, Your Honor.
All right, state's evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor, we arrest and close this. Arrest and close, Your Honor.
Court's going to review the evidence. All right, the court has reviewed the evidence. The court finds sufficient evidence to convict the defendant. The court will follow the plea agreement. Court hereby convicts Monica Rochelle Roberts of evading arrest or detention with a vehicle, a third-degree felony. Court assesses her punishment of 10 years confinement in the Texas Department of Criminal Justice. The court today suspends that sentence, places her on 7 years community supervision, orders her to pay a $2,500 fine, $290 court cost, $180 restitution, and $35 reimbursement fees. The court dismisses under section 1245 CR 22-225 possession of controlled substance, and DA 2021-1452, tampering or fabricating physical evidence. All right, Mr. Roberts, if you'll come forward. Mr. Roberts, if you'll come forward, I'm gonna have you fingerprint with Deputy Everett. Oh, I'm sorry. No, that one.
Money that's
Ms. Heisel,
sure right.
I'm gonna have the state sign this one.
No, press down. This one yet.
This is admonishments. Oh, yeah, sir.
That's all I have here. I'm gonna be
You
excused.
may be.
All right, thank you.
Enjoy your day.
Next time.
All right, Mr. Wonder, you ready?
Yes, sir.
Who do you want to call first? Riggs or Lewis? Riggs. Kenneth Allen Riggs. All right, this is cause number CR 22-362. Mr. Riggs, sir, if you'll raise your right hand, I'm going to place you on oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
Thanks, sir. You can lower your. All right, your name is Kenneth Allen Riggs, is that correct?
Yes, sir.
And Mr. Riggs, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
Yes, sir.
In this case, you're represented by your attorney, Mr. Nolan White. Are you pleased with his representation?
Yes, sir.
Do you feel like you've had enough time to talk with him about your case, have all of your legal questions answered?
Yes, sir.
You signed some paperwork with him today. Do you understand everything that you've read over and signed?
Yes, sir.
And Mr. White, do you believe that Mr. Riggs is competent today?
Your Honor, I believe it's confident, he understands the proceedings, the opinion against him here today. I also believe he's executed waiver for no one to tell him all here.
Thank you, Mr. White. All right, Mr. Riggs, in this case, you've been charged by indictment with a second-degree felony offense of possession of a controlled substance in penalty group 1 greater than or equal to 4 grams less than 200 grams. A second-degree felony in the state of Texas carries a range of punishment of not less than 2 years in prison or more than 20 years in prison, and a fine of not more than $10,000 if imposed. I see that there's a plea agreement in your case in which you would plead guilty to this crime. The state would be recommending that your sentence be assessed within that range of punishment at 8 years confinement in prison. But they're recommending that that sentence be suspended and you be placed on 8 years of probation, community supervision. In addition to that, you would be assessed a fine of $2,500, $180 in restitution, $290 in court costs, and $35 in reimbursement fees. Is that your understanding of the plea agreement?
Yes, sir.
And you're asking the court to approve this today?
Yes, sir.
All right, Mr. Riggs, then how do you plead to possession of a controlled substance?
Yes, sir.
Are you pleading guilty to this crime because you are guilty of committing this crime?
Yes, sir.
All right, Mr. Riggs, has anyone threatened, forced, or pressured you to plead guilty?
No, sir.
All right, court does accept the defendant's plea of guilt. Mr. White, any objection to the state's evidence?
Okay.
State's evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state? From the defense? Court's going to review the evidence. All right, court has reviewed the evidence and finds sufficient evidence to convict Mr. Riggs of this offense. Court will follow the plea agreement. Court hereby convicts Kenneth Allen Riggs of possession of a controlled substance, 4 grams to 200 grams, a second-degree felony. Assesses his punishment at 8 years confinement. The Texas Department of Criminal Justice suspends that sentence today, places him on community supervision for 8 years. Orders him to pay a $2,500 fine, $180 restitution, $290 in court costs, and $35 reimbursement. All right, Mr. Riggs, you hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'm gonna have you step forward to be fingerprinted, and then the probation officer will give you more information about what's next.
All right. Yeah. And don't press now.
Sure.
Do it one more time.
Okay.
I'll go again.
Then
All right, this is cause number CR 22-357, State versus Jodine Walters Lewis. Ms. Lewis, if you will raise your right hand, I'll place you under oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you can lower your hand as well. All right, Ms. Lewis, are you a United States citizen who reads, writes, and speaks English? Yes. Have you ever been diagnosed with a mental condition? You're represented by your attorney, Mr. Nolan White. Are you pleased with Mr. White's representation of you? Yes. Feel like you've had enough time to talk with him about your case and have all of your legal questions answered? Yes. Is there anything about the paperwork that you've read over and signed with him today that you do not understand? Mr. White, do you believe Ms. Lewis to be competent today?
Your Honor, I believe this was, she understands the proceeding, opinion against her. Also believe that, waiver that she is executed there in front of the court, that she's done that.
Thank you, Mr. White. All right, Ms. Lewis, you two have been charged with possession of controlled substance in penalty group 1 in an amount of greater than 4 grams or equal to 4 grams, less than 200 grams. A second degree felony does carry a range of punishment of not less than 2 years in prison or more than 20 years in prison, and a fine, if imposed, not more than $10,000. I see that the plea agreement in your case is that you will plead guilty to this crime in exchange for the state's recommendation that your sentence be set at 8 years in prison, but suspended for 8 years of community supervision or probation. In addition, you would have a $2,500 fine, $180 restitution, $290 court costs, and $35 in reimbursement fees. Is that your understanding of the pleas? And that's what you're asking the court to approve? All right, then, Ms. Lewis, how do you plead to possession of a controlled substance? Are you pleading guilty to this crime because you are guilty of committing this crime? Has anyone threatened, forced, or pressured you to plead guilty today? Court accepts the defendant's plea of guilt. Mr. White, any objection to the state's evidence?
Oh, yes.
State's evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Yes, Your Honor, I'm sure you've noticed that Ms. Lewis and Mr. Rich were co-defendants. The lab only tested one of the baggies, the 2 baggies selected, however, they did field weigh approximately the same weight. So we believe had they tested the second baggie, the weight would have been approximately the same as what came out in the one bag plus tested.
That's all. Don't have any issue.
Okay. All right, anything further from the defense? All right, then the court, having reviewed the evidence already in Mr. Riggs' case, finds that the stipulated evidence is the same in this case. The court, based on that review, finds that there is sufficient evidence to convict Ms. Lewis of this offense. Court follows the plea agreement today. Convicts Ms. Lewis of possession of a controlled substance in penalty group 1, greater than or equal to 4 grams, but less than 200 grams. Assesses her punishment at 8 years confinement in the Texas Department of Criminal Justice. Suspends that sentence today, places her on community supervision for 8 years. Orders a $2,500 fine, $180 restitution, $290 court cost, and $35 in reimbursement fees. Ms. Lewis, you hereby remained to the custody of the probation department, so they can carry out the terms and conditions of the sentence, and when you come forward to be fingerprinted, and then the probation officers will give us more information.
Right, Tom?
You ready, Mr. Duran?
Don't press the.
CR 22-65, State versus Oscar Duran, motion to revoke.
Your Honor, the last time we were here, we indicated to the court that we were trying to find something out. We resolved that. We, court also did a study of March 30th. Testing. I think that there's a fair amount of highlighting.
Okay. All right, court maintains Mr. Duran for contested hearing on March 30th. That'll be at 9 AM in this courtroom. You're free to go.
No, that's all I have.
Yes. All right, court's going to stand in recess for 20 minutes, so we'll say about 10:15. 10:15.
Yes, Your Honor.
All right, this is cause number CR 21-150, CR 20-399, State versus Lindy Sherry Delaney. All right, Ms. Delaney, if you will raise your right hand, I'm going to place you under oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God. All right, you can lower you. All right, Ms. Delaney, are you a United States citizen who reads, writes, and speaks English?
Yes.
And have you ever been diagnosed with a mental condition? In this case, you're represented by your attorney, Mr. Murleader. Are you pleased with his representation of you? You feel like you had enough time to talk with him about your case and have all your legal questions answered? Is there anything about the paperwork that you've read over and signed today that you do not understand? Mr. Murleader, do you believe your client to be competent today?
Yes, Your Honor.
And have you explained to her her rights as they pertain to this plea agreement and the consequences of a felony plea and conviction?
Yes, Your Honor.
And you believe that she understands those and that she's entering into this plea intentionally, knowingly, and voluntarily?
Yes, Your
All right, Ms. Delaney, you are charged by indictment with a second-degree felony offense of manufacture or delivery of a controlled substance in penalty group 1 between 1 grams to 4 grams. A second-degree felony carries a range of punishment of not less than 2 years in prison or more than 20 years in prison, and a fine, if imposed, not to exceed $10,000. I see that the plea agreement in your case is that you would plead guilty to that crime in exchange for the state's recommendation that your sentence be assessed today at 10 years confinement in prison, with that being suspended and you being placed on probation for 10 years, being assessed a $2,500 fine, $290 court cost, $1,005 in reimbursement fees, and $180 in restitution. The state would also be dismissing CR 21-150, which is a theft of property, between $2,500 to $30,000. Ms. Delaney, is that your understanding of the plea agreement today? And that's what you want the court to approve?
Yes.
All right, Ms. Delaney, then how do you plead to manufacture or delivery of a controlled substance in penalty group 1 between 1 grams to 4 grams? Are you pleading guilty to that crime because you are guilty of committing that crime? Has anyone threatened, forced, or pressured you to plead guilty today? All right, the court will accept the defendant's plea of guilt. Mr. Murleader, any objection to the state's evidence?
Honor.
The state's evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Yes, Your Honor. It's not reflected on the judgment because we don't have a DA control number on it yet. Ms. Delaney was arrested on the 27th of February by DPS. I provided both the lab report that's already back and the troopers report on that. It is by agreement that we are going to take that into consideration in this plea, and to account for that, the state and Ms. Delaney have agreed to make 30 days in jail as a condition of her probation to start on March the 24th by 6 p.m. And DPS is agreeing not to submit that for further prosecution.
Is that your understanding as well, Mr. Murleader?
Yes, Your Honor, just one correction. She was not arrested that day. She was taken to the hospital. From my view from the state, they're not going to issue an arrest warrant so long as it's taken into consideration.
That's correct, Your Honor. Sorry.
So is the 30 days in jail, it's not reflected in this plea at all, right? Is that-
It's not on the judgment, it's in the conditions of
Conditions.
probation. Your Honor.
All right, question to review the evidence. All right, the court has reviewed the evidence. Court finds that there is sufficient evidence to convict the defendant of this offense. Court will follow the plea agreement. Court hereby convicts Lindy Sheree Delaney the second degree felony offense of manufacture, delivery of controlled substance in penalty group 1, greater than or equal to 1 gram but less than 4 grams. Assesses her punishment today at 10 years confinement in the Texas Department of Criminal Justice. Suspends that sentence today, places her on community supervision for a period of 10 years. Orders her to pay a $2,500 fine, $290 court cost, $180 restitution, and reimbursement fees of $1,005. Court's also ordering Ms. Delaney pursuant to her agreement to serve 30 days confinement in the Van Zandt County Justice Center with credit for 3 days of time already served and 27 to serve as indicated. Is there an order of commitment for that?
I don't believe so, Your Honor.
Is there any agreement on how she's going to serve that, weekends or straight time? Straight time.
Yes, Your Honor. We asked for weekend with the distillery license, insisted on straight time, he gets 3 days prior.
Okay, so the conditions of community supervision will probably suffice. Just make sure, Ms. Delaney, when you go, that you take photographic identification with you, or they're not gonna let you in. Okay, so make sure you take an ID card or your driver's license or something so that they can identify you. All right, Ms. Delaney, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. You'll come forward to be fingerprinted, and the probation officers will give you the next steps.
Right.
That's what I have.
Yes, thank you, Mr. Marley. You doing well?
Judge,
You may.
off the record.
I was just pulled from upstairs, Miss O'Brien, showed up. She was preparing against medical difficulties, and they asked that we reset her so she was back to get the treatment.
And what are the difficulties? What did you say?
Judge, she's had some cysts that erupted, and so she's getting treatment for
Okay.
that in lots
Okay. All right, this is cause number CR 22-280, CR 22-281, State versus Miranda Jill Opry, set for pretrial. Go ahead, Mr. Meehan.
Judge, we would request additional pretrial. I've been trying to get over this upright, to go over her stuff, and she's been in and out of the hospital consistently in the past 2 months. And so we request additional pretrial from 5 over.
Any objection to this? All right, court will set Ms. Opry for pretrial. You want to do April 25th? I'm sorry, May 11th.
May 11th, Judge.
All right, Ms. Opry, you're set for pretrial on May 11th in each case. Once you sign, you're free to go.
Anytime. Tell me what to do. And then I'm also ready on research this fall.
All right, Ms. Holly.
Judge, we had reached an agreement on this Hollis case, for a pre-trial intermittent contract. However, she used some of the money that was going to be put towards her contract fee to pay pre-trial release this week. And so she didn't have to pull $500 for pre-trial contract. If we can set her on a short reset, we would be able to get that money. And take it back up here, we'll get that taken care of.
Only short one I have. I mean, we could set her on the 30th. That's a contested docket, but if it's just a matter of doing the PTI, we could do it that day.
Safe agreement with giving her some additional time. I know she owed free trial fair amount. I know that's a lot of money coming up all at one time, so.
That's only that's only 3 weeks, if I'm not mistaken. Okay, all right, the court will set Ms. Holly then to enter her. We'll just set her plea on 3:30. That'll be at 9 AM in this court. Okay. Once you sign, you're free to go. Read anyone else?
There's been a program.
She may.
You said Mr. McClellan. And
CR 22-335, State versus Benny William McFarland. No, there, let's see.
Judge, what was it cost?
CR 22-335. Mr. McFarland set for pretrial. Go ahead, Mr. Meehan.
Judge, we have no notice pre-trial this time. We've been given an offer, or I've discussed that with our client. Who has to be set for daughter call on this case.
All right, court finds no pretrial motions having been filed. The court will set this matter for docket call on May 11th at 9 AM. Can you approach real quick? Yes, Mr. Cotton, come on up. All right, this is cause number CR 22240. State versus Ronnie Dwayne Cotton. The court has already conducted the pretrial setting. The court has reset pretrial, I believe, to May 11th at Mr. Manning's request. Mr. Cotton was requested to perform a urinalysis exam by the pretrial release officer, Mr. Waddell. Mr. Waddell, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
All right, thank you. And Mr. Waddell, as the pretrial supervision officer, did you conduct a urinalysis test on Mr. Cotton today?
Yes, sir.
And what was the results of that test?
The results of the test were positive for methamphetamine and for marijuana.
And did you have any discussions with Mr. Cotton about the results of that test?
Mr. Cotton denied using either substance since the last time he was reported in February.
Any questions, Mr. Manning?
Yes, sir. Mr. Waddell, that's a field test, correct?
Yes,
And in order to receive a lab verification, you have that sent off, is that correct?
yes, sir.
And Mr. Cotton also provided information to you that he is under medical treatment for kidney issues and one or both of his kidneys, is that correct?
Yes, sir.
Okay. And as a matter of fact, he was recently hospitalized with massive kidney stones as well as a kidney disease that makes his kidneys not function at full capacity plus the more pain. Is that correct?
Yes.
And is it in your training experience, have you ever had cross contamination with prescribed medication that may lead to a false positive on a meth or marijuana type test?
I'm not aware of taking medication.
May I have a judge? And you do believe that a lab verification would further clarify the results for today's field test?
Yes.
No further questions.
Mr. Manning, what medication, if any, is Mr. Cotton on, so that we'll know whether or not that could be a.
Judge, my understanding is that he's not currently on medication, but he was on medication, and due to his kidney issues, my understanding is that the filtration of his kidneys to filter out toxins and other contaminants is altered from a normal person to read. I wouldn't know the cross contamination or effect on it would have on tests, which is why we're requesting the test.
Mr. Waddell, has Mr. Cotton ever given you a baseline on when the last time he used methamphetamine, if any?
We tested him last month and it was positive. It was not a baseline. He made the statement to me that he's used methamphetamines continuously, heavily, and that that was his explanation for being in a system. I informed him that it was my understanding that methamphetamines does not stay in your system that long, in excess of 30 days or 30 days.
What was the result of the test last month after, did we send that off for verification?
No,
You recall if there's a reason why we didn't?
because of these same discussions, because of medical problems that he was instructed, I believe, by the board as well as by me, to do his best to provide a good sample today that would remove any doubt as to whether he is using or not using.
Okay, any further questions, Mr. Manning?
No, that's not good.
All right, court's going to find that Mr. Cotton has violated the conditions of his pretrial release by providing a sample that has tested positive for methamphetamines. Court will consider reinstating the bond upon the confirmation of the lab test that determines that there is no presence of methamphetamine and or the production of any medication that would cause the field test to test positive for methamphetamine. So court will consider reinstating the bail whenever that information is brought to the court's attention, if it does.
And Mr. Cotton asked if I could go get some personal belongings from the vehicle outside, and bring those so you can take those to jail, following first.
I have no concern with that. So Mr. Cotton, your bail is found insufficient at this time for those violations. I'm gonna go have you taken into custody at this time, and I'll set new bail here shortly.
Jonathan?
Who, only things they would add to that discussion, we would ask the state that the, or look at the indictments in this files. When evaluating on it, for the violations in general.
Will do.
Right. This is their, this is the way they.
Good, so in there.
Yes, I think Mr. Manning's having to go outside to assist his son. All right, for the record, cause numbers CR 21-321, State of Texas versus James Stevens Brown. And cause number CR 22-394, State of Texas versus Kristen Lee Sipes, both were called at 9 a.m. Neither defendant were present. The names have been called again in the courthouse loudly distinctly 3 times with no response. Court hereby issues a judgment not si and alias cases. Can you check the status of Mr. Manning? We're about 20 minutes out from lunch and I'm fearful we're not gonna make it.
Court reporter gets a little, feisty. A little feisty, we're gonna be here.
I call it BS.
Yes.
All right, Mr. Manning, who are you ready?
Judge, just provide paperwork to the state. On Mr. Young, Mr. Stanley. And then I also have Mr. Waller down. Paperwork as well. I also have. So we're talking to the state about Mr. Tienda the Flash, but we can go ahead and reset them today.
All right, Mr. Tienda, CR 22-295. Set for docket call.
Judge. We are this close to a plea agreement, and there's, like I said, there's one thing they talked to the state about in regards to registration requirements. I think if we can clear that hurdle, then we'll have an agreement. So I'd like to set for a plea.
You sound concerned about that, Judge. It sounded like he was questioning that.
Given my recent conversation with Heisel, I'm not sure how that conversation went.
You want to set it for a plea?
Judge, I'd like to. I'm optimistic, despite my recent conversations.
You want to set it March 30th?
No, sir. No, sir. We set it off to 11.
All right, court will set Mr. Tienda for docket call May 11th. Charles Young. All right, this is cause numbers CR 22-345, CR 22-346. Mr. Young, if you'll raise your right hand, sir, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you got to speak up a little bit louder so my court reporter can hear you, okay? All right, your name is Charles Brandon Young, is that correct? And Mr. Young, are you a United States citizen who reads, writes, and speaks English? And have you ever been diagnosed with a mental condition? Have you ever been diagnosed with any kind of mental condition such as bipolar, schizophrenia, depression, things of that nature? Are you currently under treatment or on medication for any mental condition? Okay. Do you feel like despite that condition, you still have a rational understanding of what's going on in your case? For the most part, is there anything that you don't understand?
Judge, we did go over the conditions of probation extensively, as the conditions of probation here are quite different from where Mr. Young trouble in the Northeast. There's a little bit more involved with probation, so we discussed that. I think we were able to answer most, if not all, of his questions.
Okay, Mr. Young, you're represented today by Mr. Manning, your attorney. Are you pleased with his representation? And do you feel like you understood and had enough time to talk with him about the case? Is there anything that you don't understand? You understand everything that you've read and signed today?
Yes.
Mr. Manning, do you believe Mr. Young to be competent?
I do, Judge.
And have you explained to him his rights as they pertain to this plea agreement?
I have full time.
And do you believe that he's entering into this plea intentionally, knowingly, and voluntarily?
I do.
All right, Mr. Young, in CR 22-345, you're charged by indictment. I'm sorry, you're charged by information with the second-degree felony offense of aggravated assault with a deadly weapon. A second-degree felony in the state of Texas carries a range of punishment. It says information, is that not right?
That's my background, Judge.
Let me correct myself, Mr. Young. You are charged by indictment with a second-degree felony offense of aggravated assault with deadly weapon, which carries a range of punishment of not less than 2 years in prison or more than 20 years in prison, and a fine not to exceed $10,000 if imposed. I see the plea agreement in your case is that you would plead guilty to that charge in exchange for the state's recommendation that your sentence, that you be convicted today, that you be sentenced to 5 years in prison, but that sentence be suspended and you be placed on probation for 5 years, that you pay restitution in the amount of $11,400.62, $290 in court costs, $535 in reimbursement fees, and the state would be dismissing several cases. An assault causes bodily injury, a possession of marijuana, another aggravated assault with a deadly weapon, a possession of controlled substance, a criminal mischief, actually 2 criminal mischiefs. Is that your understanding of the plea agreement? And that's what you're asking the court to approve? All right, Mr. You have to say out loud, yes or no, because she has to write down what you say. Okay, all right, so Mr. Young, understanding all of that, how do you plead to aggravated assault with a deadly weapon? Are you pleading guilty to that crime because you are guilty of committing that crime? And has anybody threatened, forced, or pressured you to plead guilty? Court will accept the defendant's plea of guilt. Mr. Manning, any objection to the state's evidence?
No objection to state one as well.
States 1 is admitted and court takes judicial notice of the defendant's judicial confession. Anything further from the state?
The state is in compliance with victim notification. Court will notice that there is a large amount of restitution in this cause, would need to waive the fine. Additionally, there was matters of intervention as a condition of probation, as this was not family violence related offense. State defense was requested to remove that as a condition. State is in agreement if it is at the pleasure of the board to remove that.
Anything further from the defense?
Judge, I would note that when this incident occurred, Mr. Young was off his medications. He has since got back on his medications and has been able to assist in discussion of this case, the fact of the case as well as potential defenses, mitigation, and as they will discuss the ins and outs of it.
All right, clerk's gonna review the evidence. Mr. Manning, he'll need to sign that certificate of appeal there. All right, the court has reviewed the evidence. The court finds sufficient evidence to convict Mr. Young of this offense. The court will follow the plea agreement reached between the state and the defense. The court hereby convicts Charles Brandon Young of aggravated assault with a deadly weapon. The court finds that the weapon is not a firearm. Court hereby assesses his punishment at 5 years confinement in the Texas Department of Criminal Justice, suspends that sentence, places him on 5 years community supervision, orders him to pay restitution of $11,400.62, orders him to pay a court cost of $290, reimbursement fees of $535, and the court dismisses under section 1245 DA 2022-580, DA 2022-523, DA 2022-522, DA 2022-524, DA 2022-0519, and DA 2022-520. Mr. Young, you hereby remanded to the custody of the probation department so they can carry out the terms and conditions of this sentence. I'm gonna have you come forward to be fingerprinted with Deputy Everett, and then the probation officers will give you information about what's next. Dennis Ray Stanley.
Before we begin, in order to bring some clarification to some of the answers that Mr. Stanley may provide. Mr. Stanley is a sovereign citizen, and as such, when we discuss his citizenship, he is not a citizen of any other country. And we discussed how that would not apply in this particular case. This is a question in terms of he's not exposed to deportation or naturalization consequences. And it's my belief under the law that stands that the law of the United States would define him as a U.S. citizen, but he does not identify in that way. Is that correct?
Okay. All right, Mr. Stanley, then if you will, sir, if you'll raise your right hand, I'm gonna place you under oath. Sir, do you swear that the testimony you give to the court under the penalty of perjury will be the truth, the whole truth, and nothing but the truth? So if you got. Thank you. You can lower your hand. Your name is Dennis Ray Stanley, is that correct? And Mr. Stanley, have you ever been diagnosed with a mental condition? And in this case, you are represented by your attorney, Mr. Jonathan Manning. Are you pleased with his representation of you? Do you feel like you've had enough time to talk with him about your case and have all of your legal questions answered? Is there anything about the paperwork that you've read and signed today that you do not understand? You understand? Mr. Manning, do you believe that your client's competent today?
I do believe so.
And do you believe that he understands his rights and that he's entering into this plea intentionally, knowingly, and voluntarily?
Judge, I've explained his rights to him, and I do believe he understands those. He and I had some philosophical discussions about how the rights apply specifically to him as a sovereign citizen. I believe he does understand the explanation of his rights. I've explained them to him, and I do believe he's entering into this plea voluntarily.
Okay. And you've explained to him the advantages and disadvantages of a deferred adjudication plea?
I have, Judge, and he is very anxious to complete those conditions so that he can be done in off paper.
Okay. All right, Mr. Stanley, you've been indicted with a second-degree felony offense of possession of a controlled substance in penalty group 2 greater than or equal to 4 grams, less than 400 grams. Just pause right here. Off the record just a second. Did you correct the judgment on the other one that said information to indictment? We'll need to get that fixed because I think all that paperwork just went up to the clerk's office on the judgment. I marked through and circled it, but it needs to be fixed. Yeah. I'm sorry, Mr. Stanley. We'll go back on the record. Mr. Stanley, that charge is a second-degree felony, possession of controlled substance, penalty group 2, greater than or equal to 4 grams, less than 400 grams. That carries a range of punishment if convicted and sentenced to not less than 2 years in prison or more than 20 years in prison, and a fine, if imposed, not to exceed $10,000. I see that the agreement in your case is that you would plead guilty to that crime in exchange for the state's recommendation that the court not find you guilty today, consider the evidence, defer a finding of guilt, place you on community supervision for 4 years, order you to pay, this says $4,000 fine, and then also says $2,500 fine.
Judge, it is a $4,000 fine.
So it's 4,000.
It should be 4 years and 4,000.
Okay, we'll need to fix that one too. A fine of $4,000, court costs, reimbursement fees, restitution, and the state would be dismissing what appears to be 4 separate cases. Possession of controlled substance, possession of dangerous drug, display fictitious license plate, and possession of marijuana 2 ounces to 4 ounces. Is that your understanding of the plea agreement? Okay. And Mr. Stanley, do you understand that if I approve this today and place you on community supervision, if during that period of 4 years, if you violate any of the terms of the probation that you've read over and signed today, that the state could file a motion to bring you back before the court could conduct a hearing. If the court finds that you violated, the court could do several things, including convicting you of this offense, revoking you off of community supervision, and assessing your punishment anywhere between that minimum 2 years up to the maximum of 20 years. Do you understand that? And understanding that risk, you still wish to go forward? Okay. All right, then, Mr. Stanley, how do you plead to possession of controlled substance in penalty group 2 greater than or equal to 4 grams, less than 400 grams? Guilty? Are you pleading guilty because you are guilty of committing that crime? Okay. And has anyone threatened, forced, or pressured you to plead guilty? All right, court will accept the defendant's plea of guilt at this time. Mr. Manning, any objection to the state's evidence?
No objection, state one.
States one, supporting the plea is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state,
No, you're on readdressing post.
from the defense?
Nothing from the this.
All right, court will review the evidence. All right, the court has reviewed the evidence, does find that there is sufficient evidence to convict Mr. Stanley of this offense. The court will follow the plea agreement in this case. Court hereby defers a finding of guilt, places Mr. Stanley on 4 years community supervision, orders him to pay a $4,000 fine, $180 restitution, and the court orders him to pay $535 reimbursement, $290 court cost, and dismisses under section 1245 DA 2022-757, DA 2022-759, DA 2022-760, and DA 2022-756. All right, Mr. Stanley, you're hereby remanded to the custody of the probation department so they carry out the terms and conditions of this sentence. I'm going to have you come forward to be fingerprinted with Deputy Everett here, and then the probation officers will give you more information.
You're right, Tom.
Just so you're aware, I just changed that.
Caleb Wayne Waller.
Lady, you sit right here. When I'm talking.
I don't think these have been signed.
Judge, we signed our paperwork, I believe, that you turn over the table.
I don't think anybody signed that. Certificate of discovery, it's not by anyone.
That may have been from.
Is there anything else the state needs to sign, Your Honor?
This needs to be signed by the defendant. I'm saying, maybe the state too. Mr. Man, Mr. Woodward. I think if I make a finding that this is a firearm, you can remember those.
It's not a firearm.
I mean, if I make an in kind of finding that deadly weapon, I make a finding that.
It's aggravated.
It removes the liability to grant probation. Of any sort, right? Usually what we do is there's no finding at this time and it just defers. And then later. it gets to-
Yeah, Judge, I believe that's correct. I just, I was told the paperwork had been corrected to our new plea and yeah, everything else had already been signed.
This
Judge
is Miss Curry's case, so we don't know a lot about it. So let me go ahead and
I think that's.
change that.
because-
I think that's the law.
Yeah.
I'm assuming that's the agreement. If we're granting probation, then I think that's what we have to do. So I'm gonna go ahead and do that. And then if we're wrong, then
Yeah, let me see this.
benefit to the defendant.
Your head, not mine.
I'll make that finding today and I'll just mark that up. So.
I will fix that right now.
All right, Mr. Waller, this is CR 22-395. And CR 22-396. Mr. Waller, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, well, your name is Caleb Wayne Waller, is that correct?
Yes, sir.
Mr. Waller, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes.
And have you ever been diagnosed with a mental condition?
No, Your Honor.
In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning's representation?
Yes.
Do you feel like you've had enough time to talk to him about your case and that you've had all of your legal questions answered?
Yes, sir.
Is there anything about the paperwork that you've read over and signed today that you do not understand?
No, Your Honor.
Mr. Manning, do you believe Mr. Waller to be competent?
He is, Judge.
And have you explained to him his rights as they pertain to this plea agreement and also the advantages and disadvantages of a deferred adjudication plea?
We have gone over that, Judge.
And do you believe that he understands those rights, the waivers he's making herein, and that he's entering into this plea intentionally, knowingly, and voluntarily?
I do.
All right, Mr. Waller, you're charged by indictment with aggravated assault with a deadly weapon, a second-degree felony. That carries a range of punishment of not less than 2 years in prison or more than 20 years in prison, and carries an optional fine not to exceed $10,000 if imposed. I see that there's a plea agreement in your case wherein you would plead guilty to that crime in exchange for the state's recommendation that the court review the evidence, but defer a finding of guilt, place you on 6 years community supervision with a $2,000 fine, $60 restitution, $290 court cost, $590 in reimbursement fees, and a $2,000 fine, if I didn't say that. Is that your understanding of the plea agreement?
Yes, sir. You should have said.
Record, no record.
Terribly.
All right, Mr. Waller, there's an issue with your paperwork that we're gonna need to get worked out. So I'm gonna ask that you come back here at 3:30 today. Yeah, come back here at 3:30 today. Mr. Manning's gonna be over at the jail. He's got some other clients that he has to deal with. He may not be here exactly at 3:30, but it'll be at least that long before he gets here. But we'll get you taken care of today. This afternoon is what we're planning, okay? All right, we'll see you back at 3:30. All right, I believe that is,
Reset Mr. Turner for Dallas County. Are we just gonna wait until he leaves?
let's just reset him for 511. For 511 CR 21-343. State versus Marcus Turner's reset for arraignment until mail. I'm gonna recall Mr. Waller at 3:30. So the court's going to stand in recess until 1:45. 1:45.